live on TikTok, I think, and also Facebook and YouTube, and wherever else I'm being told to go. So let's talk about US immigration, the changes that have been happening, and how to prepare for them if there are ways to prepare for them. So if any of you have any questions whatsoever, please put them in the chat and I'll be more than happy to address them. So let's focus first on the fact that TPS has been canceled for Nicaragua, Honduras, Venezuela, and Haiti so far. We all know that all the other ones will be also canceled, right? So give me 1 second. Let's see. So for most of this video, I will focus on TPS and what are some of the options that people on TPS have. Now, that being said, the advice is going to be very, very general because every case is different. I have not yet in my entire career have seen 2 cases that are identical. So let's just focus on that and remember, every single case is different. So first things first, TPS will expire in some cases in August, in some cases already expired, in some cases until September. The specific country, and depending on the date of your particular designation, for Honduras, there were like 5 or 10 of them, okay? Haiti was at least 2 of them. So for each single one of those, there will be different rules will apply. So TPS may expire on a particular day, your work permit may expire on another. So you need to be very careful because the minute TPS expires, you are out of status. The minute your work permit expires, you are no longer able to legally, lawfully work in the United States. And as we all know, this current administration, that's all really they're waiting for you to slip up and do something wrong, even if you have done everything right for the past 20-something years. So TPS, that was the major change that has happened. And it's still happening. Federal Register, the TPS cancellation of Honduras and Nicaragua were just published in the Federal Register yesterday. That being said, that we are done with the TPS, what are some options that people who are coming off TPS have? It really depends on how you entered the United States, when you entered the United States, how long after entering the United States did you file for asylum, for example? What has happened in that asylum case? Did you have your interview? Did you not have an interview? If you had your interview and you were referred to the immigration judge, what happened there? Was the hearing terminated and then you are on an order of supervision with ICE? All of those things will make a difference because they do determine if you have ever entered the country without inspection. It will determine if you accumulated unlawful presence and how much unlawful presence. And that in turn determines if you have 3-year bar, 10-year bar, permanent bar, if you have to leave the United States and come back. Now, in addition to that, if you have been here a long time, okay, and even those who came last year, you may have had an employer file a perm petition for you. You may have had an employer who was willing to sponsor you, petition you. And if that is the case, then we may be able to recapture that date, especially if it was before 2001. Maybe it's coming current soon, and then you can do consular processing if you leave sooner rather than later without a waiver. You may have had that petition approved a long time ago, but it didn't go anywhere. And now all of a sudden, maybe your child who was born in the United States and is a US citizen, maybe now they can petition for you. So just because you don't think you have options doesn't mean you don't have options. you should talk to your own immigration attorney who's familiar with your case, who's familiar with your timeline, and see if there is anything that can be done, anything prior that can be recaptured to get you status in the United States or get you residency in the United States. That is not an option for everyone. So then we need to look at current options. What is it that we can do for people who are coming off TPS right now, and maybe there is something that can be done for them. So generally speaking, there are 5 ways to get residency in the United States. There is more than that, but generally speaking, it's 5 ways. Asylum. If you have been in the United States less than a year, you have up until 1 year from your date of entry to file for asylum. Under certain circumstances, you can file past the 1-year period, but talk to an immigration attorney before you do so because the rules are different. Second, green card lottery. Green card lottery for some countries is available, for some it's not. Some countries are always excluded every single year because the number of immigrants from that particular country exceeds the quota. So if the green card lottery is something that is available for your country, then you should apply for that green card lottery. And if you do get selected next year, you go through the consular processing. That may not be an option if you are accumulating or you have accumulated unlawful presence. It may be an option, on the other hand, if you have a qualifying relative for a waiver of the unlawful presence. Now, obviously, anything that I mentioned does not take into account any complications in your case, doesn't take into account criminal records, doesn't consider any of that. So we're talking plain vanilla here, okay? Then, so we discussed green card lottery, we discussed asylum. Third one is visa by investment. If you can invest over 800,000, most likely $1 million, plus the fees comes to about 1.1. So if you have that kind of money, you probably wouldn't have been on TPS to begin with, but I have had a person on TPS with that situation who was able to do that. So that is an option. And then you're down to 2 separate options, right? Family petitions and employment petitions, okay? Give me 1 second. So employment-based petitions. If the employer petitions for you or has petitioned for you in the past, and you have a copy of that petition, whether it was approved or not, just file it. We would like to see those. We need to see if that counts as, maybe it was before 2001, maybe it was before 1996. There are different times in an immigration case lifetime that you may be eligible for relief based on an application that was simply filed, not necessarily approved. So look at that. That being said, if employment-based is not an option, then the employer can petition for you right now. It is still a process that the employer may need to go through. So unless you qualify for an EB-1A or an EB-2 national interest waiver, then you very likely need an employer to sponsor you. For an employer to sponsor you, it's a multi-step process. First, they need to do the prevailing wage determination with the Department of Labor. Once that is approved, they need to do recruitment and then do the perm labor certification. Comes from the word permanent because you're applying for permanent residency. And once that is certified and approved by the Department of Labor, then the employer can petition for you with USCIS. When that is approved, you can apply for a green card from within the United States if you're here lawfully and you have not accumulated unlawful presence, or you can do consular processing. For purposes of a green card, time spent in TPS status does not count towards adjustment of status, does not count as being in lawful status. So you will need to consular process nevertheless. And of course, then we are back to qualifying relatives. So keep those things in mind. And then we have the family petition. Obviously, easiest way possible is if you are married to a US citizen or someone who maybe when you guys got married, didn't have status, then it became permanent resident, maybe petitioned for you, but then became a citizen later on. You might be able to obtain status if you enter the country lawfully and you don't have any of the other aggravating factors. So let's focus on those things, okay? And let's see if any of you have any questions, and let's go over that. Let's see. All right. Oh, thanks for all the love, guys and girls. Okay, let's see. All right, so let's talk about period of authorized stay by the Attorney General. So if you are in the United States, and let's say you overstayed your visa. We hear this all the time. Well, I have my green card application and I filed it, and now I'm protected because I'm married to a US citizen. Let's make a few things very, very clear. If you entered the country with a visa and you overstayed your visa, just because you married a US citizen, it does not mean you have a lawful status in the United States. Marriage alone grants you no status. Then you apply for the permanent residency, you file your 485 along with everything else. Again, people think they are in status. No, you are not in status. You are in a period of authorized stay by the Attorney General, and that can be rescinded at any time by the Attorney General. So what does that mean? It means that if at the time you filed the application, your visa was already expired, or who knows what the complications are, or you entered in a parole that's no longer valid, or whatever. If that is the case, then you do not, even if you have a period of authorized stay by the Attorney General can rescind that and you can be deported. You can be removed from the United States. Now, whether you are entitled to see an immigration judge or not see an immigration judge depends on multiple factors, okay? It depends on how you enter the country, visa waiver, ESTA, Canadian waiver, some other waiver. Did you enter on parole? Did you enter through the border and you got interaction with ICE? Because if you had an interaction with ICE, then how long you've been here, it really will not matter if they issued a notice to appear and they filed that with the court. That is what stops the count. So you could say, oh, I have been here longer than 2 years and I'm not subject to expedited removal. Well, the truth is you are, because you had your NTA issued in the first 2 years from entry, because it was issued to you when you got caught at the border or when you turned yourself in at the border, okay? So we see that a lot. Keep that in mind. Having a period of authorized stay by the Attorney General, meaning you have a green card application pending, again, should grant you status, has been historically for the past 40 years granting you a reprieve from removal, a break from removal, some sort of protection. It does not anymore. It never had. It was just never enforced. So right now they don't care and they are going to pick up anybody and everybody. So married to a US citizen does not grant you status. Filing the marriage-based petition doesn't grant you status. Having a permanent residency in your hand grants you permanent residency, nothing less. Just, we hear this a lot as well. It's like, well, I got my work permit, so I should be fine. When am I getting my green card? Not so fast. Just because you got your work permit does not mean you are getting your green card. It just means that they got to this part of the process and you meet the criteria for a work permit, which is a different criteria than it is for residency. So one is residency and one is work permit. Totally different things, different timelines, different everything else. So, oh, look, there is a question. Can I travel outside of the country and return with no issue under TPS? No, absolutely not. And it varies and it depends on so many different factors. So let's talk about that first. How did you enter the United States on TPS? How long ago? Third, if you are traveling outside the United States while you are on TPS, did you obtain an advance parole? Do you have an emergency right now that makes you eligible for an emergency advance parole? And then can you travel on that advance parole? And if you do travel, what does that do to you? This gets even more complicated if, for example, you came in and then at some point you filed for asylum and the asylum has never been adjudicated, there is no decision made. You cannot possibly travel outside the US and go to your home country from which you're claiming asylum, because that would make no sense. Now, if let's say you're from Venezuela and you need to travel to France because that's where your company is sending you for work, then you can request an advance parole document to travel there for that work purpose, okay? So keep those in mind. Now, further, if you have a removal order, you should not leave the United States. You have a removal order and you're traveling outside the United States with a removal order, you could be self-deporting, okay? If you have a criminal record and you are traveling outside the United States, again, you could be self-deporting, and then you need to worry about not only removability, which is when you leave the United States, but are you admissible to come back into the United States when you want to come back? And that's different rules. So all of these things matter. There is no simple question as to should you travel outside the United States if you have TPS. Further, what if they terminate TPS while you're outside the United States? Do you really want to take that risk? Definitely not, and definitely not without an advance parole. So thank you for that question. That was a good question. Fabulous. Anybody else has any questions? Let's see. No? Okay. Let's see. Okay. Fabulous. So we talked about TPS, we talked about TPS terminating, we talked about applying for residency based on asylum and what are the rules there. Those have changed a month ago, and so on. So Fabian wants to know, can TPS lead to permanent residency or green card? Well, thanks for the question. So first, permanent residency or green card are the exact same thing, okay? So they are interchangeably used. Proof of permanent residency is the card, okay? Now, TPS, it's temporary protective status, means temporary. As you can see, temporary cannot lead to permanent, at least not directly, okay? People on TPS who want to achieve permanent residency need to have an independent basis on which they can apply for residency. And I don't know when you joined us, but there are generally 5 ways to get permanent residency in the United States: family petition, investment, employment, asylum, and green card lottery. Generally speaking, those are the options. So no, TPS does not directly lead to residency. What we see most of the time, it's either an employer who petitioned or the child is now 21 and petitions for the parents. And sometimes when an employer petitions and it eventually comes to fruition, and then the person can go and apply at the consulate for permanent residency. Also, many people on TPS who happen to have entered the United States without inspection, if they were able to travel on advance parole, and they have traveled on advance parole, may now be able to apply for residency, assuming no other complications, from within the United States without doing consular processing, so they could adjust the status. But no, there is no direct lead between TPS and permanent residency. All right. Let's see. Good. Thanks for those questions. Those are really good questions. And I know you guys are worried. My pleasure, Fabian. Esteban. Okay. All right. If there are no more questions, we are going to end this live today, and we're going to try again in a couple of days. And I'm sure I'll have some updates because things change on immigration every single day. So I'll address as much as I can as soon as they come. So if you guys have any questions, please put them in the chats or message us directly, and I'll address them on the next live. Okay? I usually go live around 3 p.m. or about this time. Okay? Bye.